Hi, and good morning, everyone. It is great to be here with you in this virtual event. My name is Ajmal Nazir, and I'm the current chairman of TTMAG, the convener of this event. Our mission today is to welcome you, warm you up, and then hand you over to our facilitator. So once again, good morning, everyone. A special morning and thanks to our panelists. Amelia Barthel, co-founder, privacy consultant, and advisor, Managed Privacy Canada. Bartlett Morgan, corporate commercial attorney at law, Barbados. Vashti Maharaj, corporate commercial attorney at law, Vashti Maharaj, Director Legal Services, Ministry of the Attorney General and Legal Affairs, Trinidad and Tobago. Distinguished guests, overseas participants, and also I would like to welcome our many new as well as our returning participants. Before we dive in, I would like to give you a brief intro to TTMAG, the Trinidad and Tobago Multi-Stakeholder Advisory Group. You should see a slide come up on your screens about now. No, these are not the finalists for Trinidad's next models, but these individuals are the directors of TTMAG. TTMAG is a non-profit organization involved in furthering internet governance and interrelated policies, capacity building, and bringing people together for constructive dialogue. Our members are diverse, representing many different stakeholder groups, as are our directors who have been put forward by their respective stakeholder members. If you'd like to get further information on us or would like to engage us, then you can visit our website, mag.tt. I was instructed to set the tone for the subject to be discussed by our panel on CDPR, Caribbean Data Protection Regulations. When I was asked to do this, I immediately thought about the ancient blessing or curse, depending on how you think about it. May you live in interesting times. Well, there's little doubt that we are living in interesting times. With increasing environmental impacts and changing weather patterns, changing global alliances, political populism on the rise. First, we had the Brexit and then America first. With blockchain and crypto resurfacing, machine learning and AI starting to replace jobs, electric cars and the race to space all reaching their pinnacles, and IoT is no longer on the horizon, but in our present everyday life. There's rising powers, both military and commercially, shifting balances of powers, terrorist attacks, digital divide, wealth divide, are all contributing to a very polarized scenarios, resulting in polarized societies. As one of these on their own could have made a strong case for the so-called rare black swan scenario, it's more like ducks in a pond these times. And what may have been considered as a far stretch of the imagination to be thinking of the unthinkable for a few individuals branded as conspiracy theorists with overactive imaginations is now a common cocktail chitter-chatter. For all of us who are leaders in the public or private sectors, pioneers and thought provokers, policy and decision makers, as well as those advisors to the decision makers. These are no doubt crazy, stressful, and interesting times indeed. Now, as impactful as these may have been or will be in the future, there is nothing, and I mean nothing, that has forced us to change, respond, or disrupt our way of life than COVID-19. It has shown us that as smart and sophisticated as we may think we are, our way of life, our infrastructure, and how we manage ourselves is still very vulnerable and fragile. To start moving into this topic area, we were always becoming more wired and connected to the internet. Data is always growing. Since the start of the millennium, with the rise of the social media, our lives are increasingly being shared around the world. Businesses have followed to become connected and engage the social media way. Some led and others followed, but all the rivers are flowing to the same sea. COVID came and just accelerated these trends. It was difficult and slow. Companies using new mediums and learn to work in new ways. In the ever-changing area of technology and communication, there are always concerns about data. Who has it and who owns it? How it can be used and how it can be abused? What protection needs to be in place and who should be allowed to monetize it and in what way? There are endless examples from commercial competitive advantages or monopolies to market manipulation to political voting influence, and more concerning, manipulating the individual subconscious mind. The area is vast, the impact even larger, and the unknown impact far greater than we can imagine. Today, we are here to discuss CDPR. CDPR is a collaborative effort by many in the Caribbean to emulate our own version of the GDPR, a framework of regulations by the EU that governs how the data of EU citizens is to be handled. We had a discussion on this in January of 2020, pre-COVID, when two of our today's three panelists also joined us to discuss the idea, and now almost a year later, we are back with a follow-up and also other response to the new dynamics. We have convened today's event to build on the session from January and also to assess where the ecosystem is heading and how we should participate. Hopefully, we will have some takeaways to continue our work on, as well as to engage our public bodies to look into some of the pressing issues that should be considered at a national and/or regional policy level. I will leave the more finer points for our panel of experts to discuss and share with us, but I encourage you to fully participate, ask questions while you have access to these learned individuals. Finally, I hope you're warm enough for me to hand you over to our event facilitator, Mr. George Gobin. And with those brief words, I would end by once again thanking everyone that is here today participating in this important event. Thank you.
Good morning, everyone. Tim Spa, Italy, 27.8 million euros. Vodafone España, 120k euros. Google, Sweden, 7 million euros. Royal Dutch Tennis Association, 525,000 euros. Post Group out of Finland, 100,000 euros. Google France, 50 million euros. British Airways, 204 million euros in 2019 and reduced to 20 million euros in 2020. Really, what do all these companies have in common? They have all been fined this year for breaches of the GDPR regulations in the European Union, where their customers' personal identifiable information, or PII as we know it, was leaked on the web. Good morning again. My name is George Gobin, and I'm a director with the Trinidad and Tobago Multi-Stakeholders Advisory Group. I'm so very pleased to be your facilitator for this event this morning on this topic called a discussion on Caribbean data protection regulations. And I'm pleased to see all of you online. We did have about 220 people registered online. So hopefully we will see them all coming on before the morning is out. So trust and privacy would seem to be quite simple concepts. And yet if you try to define them in relation to what today's technology allows you to do or access, we quickly run into challenges. If you try to explain why you trust something or what that privacy is a personal belief, you would quickly realize that people will have different responses as to what those terms mean. Even for countries, it seems, have different ideas and responses on how to resolve this issue of trust and data privacy. In fact, if you looked at your own homes, your children have a totally different idea of what is privacy as opposed to your own views. In 2016, we saw the European Union launch GDPR. GDPR is short for General Data Protection Regulation, and it's the name of the law in the European Union that sets out to protect the rights of individuals in respect of their data. This means that any organization that holds data about any resident of the EU is expected to comply with the GDPR. Is it time, therefore, for us to consider a Caribbean perspective on how we address our own privacy and trust issues through a similar engine called the the Caribbean Data Protection Regulation? What we at the TTMAG are trying to do is to get a consensus with our fellow organizations and countries in the Caribbean region to come to a decision very quickly on whether this is something each country should do on their own, or whether we should be like the EU and agree on a Caribbean data protection regulation model to help us manage privacy issues consistently. This panel will discuss the following three items. One, the status of what is already reviewed in Canada and regionally in the Caribbean with respect to CDPR. Two, we will discuss pros and cons of storing country and citizens' data in country in the Caribbean, or do we store it internationally? And by this we mean, if we do implement CDPR in the Caribbean and we store our data in another country that is not a signatory to the CDPR and or has their own rules or actually no rules, how then do we address data privacy liability issues based on geographic storage location of data? Thirdly, recommendations on the way forward for CDPR implementation. This is most important for us as we'd like to have an accord going forward that we can try to table this discussion at the next CARICOM Heads of Government meeting. We can't stress enough how important your feedback on this is for us. The format of today's discussion will be done via presentations from our distinguished panel of speakers for about 90 minutes, and then the rest of the time this morning will be dedicated to some questions and a wrap-up session. Please place your questions as they arise to the specific panelists, if you wish, on the chat in the Zoom call, and they will be responded to in arrival sequence. If we're not able to answer all your questions today, we will try to get these panelists to respond subsequently, and these will be posted on our website at www.mag.tt. Finally, before we begin, this session will be recorded with screenshots of our audience being used for promotional purposes, and the recording will be posted on our website. If you consider this to be a breach of your privacy, I wish to confirm that you are in the right seminar, as we are talking about you and your data privacy, so please feel free to disconnect your video at your convenience. Thank you. Our first speaker today is Ms. Amalia Barthel. Amalia is a privacy consultant and advisor and a lecturer and academic programs advisor for the University of Toronto School of Continuing Studies. Amalia has been in privacy compliance and the engineering space for 16 plus years and is a passionate advocate for protecting personal data of individuals. For the past 6+ years, Amalia has been helping multinational companies as well as small and medium size in the top 20 industry sectors realize the most benefits through the lawful use of collected personal data through an innovative risk-based low-impact approach to assessing and building privacy compliance programs suitable for each client. Amalia is the lead contributor for the Privacy Management Certificate Program at the School of Continuing Studies at the University of Toronto based on COVID-5 and the ISACA privacy principles. Amalia is also the co-founder of the Managed Privacy Canada, the leading privacy as a service practice in Canada, and she is based in the Toronto area. Please join me in welcoming Amalia to this, her first virtual visit to the Caribbean and her first presentation being delivered to a Caribbean audience. Welcome, Amalia.
Thank you so much for that very generous introduction. Oh, am I muted? No.
Now we're hearing you.
Okay.
So you can go ahead and present, Amalia.
Okay. So I'm going to share my screen. And I'm going to make it full screen. And if you bear with me with a second, I'm starting my timer so I can keep myself on track. And here we go. I'm going to try my best to give you an overview of what's happening in Canada. And I love the chairman's introduction, and thank you for the very generous introduction once more. What an interesting year we're having. Aside from COVID, which was not at all welcome and is not a pleasant event for anyone, in Canada, we have been very concerned, preoccupied with the lack of updates in our privacy legislation, and that's what I want to talk to you about today. And I love that your chairman wanted to warm up the audience. It's a different approach with Canada. We break the ice. That's my backyard right now. Unfortunately, I can't show it to you on Zoom, but that was my planned picture for Zoom. So much so that we make our own northern lights, but we're in the south of Canada, so it's more the southern lights. And as we all know, just like your MC here, George said, if you're not comfortable, well, look at what some other people have not been comfortable with, and look what happened to them. It's all, in good spirits, and we're all having a lot of laughs with these video calls and the world of Zooms and webcasts and so on. The most important thing is to just keep going. If there's a technology glitch, we are the humans. We can overcome anything. So if there's any glitch, please just remain patient. We will go through it. So I'm hoping I broke the ice, and I will now go to more serious things. I want you to know that I absolutely love privacy, but I'm trying to now make it into a very all serious and frowny type of topic. So I'm hoping it's not going to be a very heavy presentation. All right, so Canada has a lot of privacy regulations, and what you're seeing here is a map of Canada. I'm in the province that has ON. It's like a yellow, mustardy yellow. And as you can see, we have just 3 provincial regulations, but on top we have the federal regulation called PIPEDA. PIPEDA is now, and we'll get to it, is now kind of undergoing a major change. There's just a bill being proposed in the House of Commons. PIPEDA is covering commercial organizations, and there's a long list of them, but there have been quite a few organizations that have been kind of falling through the cracks, mainly political parties, which is a big issue for us in Canada, because they really don't know how to protect personal information. And also school boards. So there's little pockets that kind of fell through the cracks in all of these regulations. As you can see, every province has at least 1 or 2 of their own. I think there's only 1 territory that does not have regulations. They do. So my mistake. So as you can see, every single province or territory has a ton of regulations. Mainly BC and Alberta, they are very strong on having their own version of a PIPEDA. So it's like a privacy legislation for commercial organizations, for commerce. And of course, they have either a freedom of information or a health information separate legislation. So as you can imagine, even for organizations in Canada, it's a little bit difficult to wrap your head around how many of these legislations apply to you and to understand the differences and to be able to comply accordingly. So we don't think that it's a good idea to have this many, but because we are a federation, well, there's no choice. However, we are trying to advance the a framework type approach. So instead of having PIPEDA, which stands for Personal Information Protection and Electronic Documents Act, our Minister for Innovation, Education and Science has tabled a set of laws, a framework under the Canada Digital Act. So under this Digital Act, there's proposal to modernize many laws, including the privacy law. And the privacy law is being divided in two separate acts. One is dealing precisely with what are the rules that commercial organizations need to comply with. And the other one is about the powers of the regulator. And they're actually introducing the idea of a tribunal, which is parallel to the regulator. So two different acts. One deals with how organizations need to comply. One deals with what are the enforcement powers. And we'll get into why. Well, as you can see here, this is a list of mainly organizations that have either enacted GDPR-like laws, or they're currently like New Zealand that are enacting laws. And even if we were to compare Canada with the other 10 countries that are under the adequacy regime for Europe, which means that the European Union has deemed their regimes and their laws adequate in terms of protection of personal information that goes from a European country to the other adequate country. Canada being one of the recipients of that great protection, the adequacy. If we look at, is your privacy law last updated? Do you define privacy as a human right? Do you have rulemaking authority? Can you demonstrate accountability? Order making powers, administrative powers, private right of action. None of this was in our PIPEDA law. They're all now proposed in our current law. And you're starting to understand and uncover as to why, because it's great when you are a participant in such a huge market like European Union, 28 countries, to have this wonderful status, privileged status of what I called, I can transfer data without headaches back and forth, which is phenomenal for commerce. So this is what we're all trying to protect. We're trying to protect how we interact with other countries on a commercial level. So you're going to be surprised that privacy is not a human right. It's not a human right in the Charter of Rights and Freedoms in Canada, specifically called out, but the application of the law has been very close to the values that Europeans have, where privacy is inscribed as a human right in their charter in Section 108. So this is one of the reasons why Canada has always been a darling for Europe. So we've had this adequacy status. There are many flaws, and this is the reason why now our law is being revised, and a lot of great protections are being added. I love geography and I love maps because it's so much easier to keep track. So what I want you, and of course I want to give credit to KPMG. I'm not affiliated to them, but with them, but I took this chart map from one of their publications. What I want you to see is how much progress has been happening in the world. So they issued this in June. Of course, China did not have a law back then or proposed bill. Canada didn't have a proposed bill. California didn't have their new uh, CPRA proposed update to the CCPA, which was already deemed as a very strict Consumer Privacy Act. As you can see, US has a ton of laws, but federal level, they are lacking an integrated privacy regulation that applies federally to all their states. That remains to be seen, and there's a lot of talk that perhaps under this new administration that may happen. What I want to draw your attention to is the top left corner. New York has enabled a very comprehensive cybersecurity law for financial services. Canada has a similar approach. But what is interesting with New York is the fact that they are talking about data governance. And we've just seen in the European Parliament and in the European Parliament that a new proposed law for data governance has been issued. So again, these are trends. This is what's happening out there. We see that countries are keeping up and catching up with the GDPR, like Brazil, who's just this year they've approved their lei for the general data protection, and I don't know exactly all the Portuguese words for the LGPD, but they have enacted a similar law to GDPR. They are saying they're actually is quite strict and one of the closest to GDPR. Canada is trying to combine an approach of consumer type and data protection rights, again, through the two acts. We have seen that Japan has received partial adequacy with EU, meaning they can transfer data. And of course, we have the whole unknown still with Brexit. Funny enough, Canada and UK, they have just signed a commercial agreement where they're going to have the same tariffs as before, and then lower, incentives. So lower tariffs, incentives for commerce, and it looks like data will be flowing between the two countries. We don't know under what type of a framework, because UK exiting the European Union is also uncertain whether they will receive adequacy or not. The main issue is the what we call the 5 Eyes, and Canada is a signatory of that, which is about surveillance. So Australia, Canada, UK, there's a number of countries that are signing this 5 Eyes. They're part of this group, and that's been frowned upon by the European Union. As you know, they're very sensitive to surveillance, to government surveillance. So India is actually also working on an amended upcoming privacy law. As I said, China is PIPL is their new proposed law, and there's still been discussions on that. So lots going on many fronts with the privacy around the world. Why does it matter? It matters because we've had so many disasters in the last few years, particularly impactful for Canadians. And this is something you may want to keep in mind. We've had a very difficult situation with two US companies, Equifax and Marriott. And I didn't put Marriott here, but with Equifax, the breach affected many Canadians, yet our regulators did not have the powers to reach and improve the situation for Canadians. In particular, we were not offered credit monitoring by Equifax, even though there's been a massive breach in Canadian accounts. Our regulator was not able to, work with Equifax US the right relief for the Canadian accounts that were breaches. Yahoo, we all use Yahoo, I don't know, around the world. US voters had many problems around, in the past years, not in this election. Marriott, I personally had to go and ask for my data to see what was breached, luckily, and that's actually not good, but it worked well in their situation. My data was very stale. It was from a name change ago. I changed my last name a few years ago. They had my last name from previous, and which was great because there would be no issue for me for fraud. They can fraud that last name all they want because nobody has that name. But they had stale data, which is actually bad for business, but that worked in their advantage because what was breached was not of a lot of value. Not sure for Canadians, but maybe for the US had more value. And of course, we have these, the last point, Uber attempted to conceal a breach, but Uber has done a lot of other things, and I don't want to badmouth them. I just want you to be aware of the situation. They have also done a lot of interference with competition and interference in a negative way. So they haven't been fair. Now, what you're also going to see where you saw that big map of the world with tons of legislation, what I'd like you to also think is that competition legislators and regulators are now interfacing and overlapping with privacy. In particular, in Canada, we have had a record $10 million fine issued to Facebook, which would have never happened under the current privacy commissioner because they don't have that kind of order making power or fining making power. But the Competition Bureau of Canada was able to establish that there's been a breach of that law, and in particular with respect to how personal data was being collected and used. As you have heard, all the scandals, and therefore they've issued a phenomenal fine that has never been seen in Canada. So things are happening. There's, like I said, data governance law is coming in the EU. There's been competition law regulators in Germany that have been fining companies. In fact, they've told Facebook they don't want them to exist in Germany. So there's a lot more forces that are actually helping bringing to the surface privacy rights and our personal data protection rights. As your MC is, specifically said, and your chairman, trust is a key issue. And with competition increasing, how you behave and your truth is the most important. And I'm saying that, and maybe I'm just idealistic, but I do believe that disinformation, and I will twist that a little bit, disinformation in the sense of even which we are entering into the behavior society, the fact that we are being tracked with everything we do and everything we say, Zoom recordings, and we know Zoom has had problems. They are now under an FTC order to repair security issues, but people are still complaining of privacy issues. It's about the fact that distortion and manipulation has been growing exponentially, and that is not the way our world should be. And including how we deal with competition, including how we deal with consumer information and their expectations from the online world. The online world is now what we know. I don't know how easy it is for you to go into shops and buy physical things from shops, but right now we're in the region where I am, we have a new lockdown. So we have about 28 days where we can go to grocery stores and the liquor store, and that's about it. And maybe the post office. So everything else we procure is online. And online, you have to remember our persona is represented or has many facets in terms of how we interact. We want to be private as a person. We want to have privacy of communications. We expect that. We expect that from the companies we want to buy goods and services from, or if we are a commercial organization we want to partner with. We have privacy of thoughts, feelings, and beliefs. That should be our own. We should not have to hide those. And that's part of our privacy as an individual. We have physical privacy, facial, and I've just been on moderating a panel on biometrics, and that's a fascinating area and very dangerous for misuse. Privacy of behaviors and actions, which is about us being online and being constantly measured and tracked and analyzed as to what we clicked on, what do we want to buy next, and being thrown into getting advertisements of different things so we can be pestered to buy stuff. Privacy of data and images, of course, photos and videos, privacy of association, and the territorial, which was alluded to, but that's the territorial is more about me traveling, me going somewhere and having my phone enabled with geolocation. What is that geolocation being used for? Is it being used for good, or is it being used for nefarious things? This is the expectation our customers have of us. Everything that we expect as an individual, our customers expect as well. So this is something to keep in mind. What are the pain points? Top of the list everywhere I looked, third-party vendors, our partners as a commercial organization. We want them to have the same levels of protections and measures. Then we have jurisdictional, and this kind of alludes to Schrems too. And if you haven't been following, this is a new judgment by the European Court of Justice that is basically saying, with this amount of surveillance that is happening in the United States, our GDPR, the rights of our European customers, consumers, are actually being infringed upon. And we no longer trust to transfer data in the US, and that's a big problem. So in order to transfer data in the US, we now have a different way of doing it. There's some instruments that are called standard contractual clauses, but they have been amended. So now there's an army of lawyers that have to go and look through all of the terms and conditions to realign them. Plus, because in the United States, they've identified a number of laws that actually supersede the GDPR. So the local laws are saying, no, but we have the right to go and check the data. They're saying you have to encrypt the data, you have to do different things so that these laws cannot actually interfere with the data. So this is a very big deal. This is a very big deal. It's still in motions. Now in Canada, what we're seeing is a lot more class action lawsuits. There's this tort of intrusion upon seclusion that's been recognized. So basically, we don't have privacy for human rights, but in the courts, privacy is recognized as a right. And the fact that we now have individuals can take action. Also, the fact that we have class action lawsuits, this is not is new. Canada has not had that kind of perspective on having to take to court people and organizations. Then we have the interpretation of harm in Canada, which has a lower threshold. You don't actually have to physically show harm, or otherwise there's actually has to be understanding that that is a potential to happen. If that's strong, then there will be penalties. And we talked about the redress that is now which is the regulators have been able to act on different complaints, the adequacy status. So being able to demonstrate you are at the same level of protection as with the GDPR or other laws. Additional accountability and rigor in contracts. We're talking about audits and certifications. And privacy by design, that is becoming very, very important, talked about as a Canadian-born concept. I know I'm looking at the time and I'm trying to go a little faster, but I don't want to brush aside anything that is important.
You have 5 minutes more.
Thank you. What are the unintended consequences? Harm. And all of this chart takes you through the entire life cycle from collection to transfer to use, storage, and disposal. What are all the harms we call them unintended consequences because we don't want to think that people are doing this on purpose, but you will have exposure, blackmail, appropriation, distortion, insecurity, invasion, re-identification, secondary uses, which means I haven't told you, but I'm using this data again for something else that I haven't told you, interception, surveillance, interrogation. All of these are harms that can happen to an individual, and they can have very, from mild to very serious consequences. We've talked quite a bit about that change is the only constant, and about these new, situations occurring with Quebec is introducing a bill that's a province in Canada, a very strong bill. Of course, China. What we're seeing and things that you should take away is we're looking at a lot more threat risk assessments, data protection impact assessment, and something new, transfer risk assessment. So can I transfer to that country? And transparency risk assessments. And that's a new thing that is kind of coming up to the surface in the new proposed Canadian law called CPPA, Consumer Privacy Protection Act. And the second one is the Tribunal Act. But transparency as to your practices, how are you demonstrating accountability and compliance? To the point of accountability, which is almost my last slide, you need to demonstrate through your C-level, your boards, that you're actually taking seriously privacy protections. And there's actually some of the laws that we discussed in the US as well, where actually C executives can go to jail for breach, not just of fiduciary duties, for breach or misrepresentation of their compliance status. Privacy is now part of corporate liability. Security has been a part for some time, but you have to think of breach of contractual obligations. So while you're also worried about your executives, and you have to keep them informed, and they have to understand the obligations and not misrepresent your status of compliance, you have to look into your contracts. What have you promised? You have a website and you have a privacy notice. What have you promised in that privacy notice? Are you actually, do you have those practices implemented into your organization? Of course, breach of legislation, and we have seen, George has given some examples of how many fines have been floating around for different organizations. And we will address a little bit later about codes of conduct and certification schemes. But you have to understand the increased accountability is where we're going with this whole world, what's been going on with developments. Very quickly, this is something that my company that I'm a co-founder, Managed Privacy, we are putting out a lot of thought leadership and a lot of papers and blogs to help organizations. You need to realize where your company belongs in order to enact your proper privacy protections and your proper privacy program. If you look at the bottom here, this is where you're starting to grow into data dependence. So this is a mom and pop shop, or and you don't have that much personal information. As you navigate towards the lower right corner of the quadrant, you're starting to accumulate data. As you go further up to the left corner is where you have data and you're starting to accumulate volume, and it's more of an enterprise look. And if you navigate all the way to the right top corner is where the impact of negligence is the biggest. This is where we have the large multinationals, the marketing, insurance companies, financials, hospitals, and they have to really take the necessary steps to implement comprehensive programs and demonstrate accountability. What we're showing to the right, the other quadrant, is in orange, we have the GDPR type organizations that need to comply with GDPR, and then the blue is organizations that need to comply with Canadian legislation. And what we're saying to you is get in the safe zone. The safe zone is where you see the colored quadrants. That's where you have the right privacy program. That's where you have the right controls. When you're outside, you have lost control of some of the privacy rights that people have. So you need to get in the zone. You need to get into the safe zone. Take action, assess your risk for exposure. And we're providing a lot of, like I said, thought leadership and tools and support for organizations. Monitor, measure, and report. You have the board you have to report to, but you have your own clients and your own contract, third-party partners. So you have to tell them that what you're doing is right and is up to the level they expect. And be proactive. And I got a little spelling error. Be proactive. Don't wait for the regulation. We think that you can do the right thing. You don't have to wait for regulation. I have documented over 35 frameworks, and I'm not going to start writing some guidance on that. There's my timer. And I'm inviting you to come to our LinkedIn page to see the guidance we're going to issue in the next few weeks, talking to you about how you can take frameworks and adapt them for your organization, whether you're multinational, whether you're small. What are the main components that you need to have to demonstrate that you're doing the right things? This is not about anything other than doing the right thing to get into the data protection safe zone. And thank you very much.
Thank you very much, Amalia. Great presentation. And I know you previously warned me that you may be running over a bit, and that's fine.
I tried my best. I even timed myself.
So we're going to go over to the second presenter today, which is going to be, if I can get my screen up, Bartlett Morgan. And let me just get you. So our second speaker today is Bartlett Morgan. Bartlett is a corporate commercial attorney at law based in Barbados. He advises clients with an interest in the Caribbean on complying with data privacy, cybersecurity, and other digital law obligations, enforcing intellectual property rights, investing in the fintech space, and navigating various telecommunications regulatory frameworks in the region. Bartlett is a respected thought leader on digital law and policy issues impacting the Caribbean. In this regard, he's regularly called upon to speak and write on issues on the intersection of law, people, and technology. He's a member of the International Association of Privacy Professionals, the IAPP. Please join me in welcoming Bartlett to this event from Barbados. Bartlett continues to be a trusted advisor for the TTMAG and is always willing to share his knowledge with us at these events. Bartlett, over to you. I've stopped sharing.
All right. Thank you very much. Hi, everybody. Thanks again to the TTMAG for having me. It's absolutely my pleasure to be here, and I am absolutely honored to be a part of this conversation. Now, this idea that is in the title of the overall webinar today, Caribbean Data Protection Regulation. It's not a new idea. It's something that we have, I think, variously throughout the region been discussing, but actively discussing, I think, for the better part of maybe two and a half years at this point. And I think what I want to do today is to more or less do two things. Do a quick survey of the landscape in the Caribbean as it regards data privacy. But importantly, also, I want to do that to sort of set up where it is we may end up. And so in the larger scheme of things, I think what I really want to do is to see how I could, I think, present some points that will help to facilitate a larger conversation, ultimately, that will help to steer this conversation about the possibilities of a Caribbean data protection regulation a little bit further and perhaps into, I guess, more clear-cut territory on the potentials for seeing this as a reality, if there is such a potential. Now, very quickly, as I would have intimated earlier, this is essentially how I want to break down the presentation today. Keeping it really simple. Where are we? What's on the immediate horizon? And then from there, I think we want to get into the whole point of, well, where can we go with this? You know, where do we go with this whole idea of a potential Caribbean data protection regulation? Now, I think it's really important to start at the beginning, so to speak. And so the question is, well, where are we today in terms of data protection in the Caribbean? What is actually going on? You know, what kind of rights, what kind of overall framework do we have at play today to protect this very nebulous concept that we refer to as, you know, our privacy right? Uh, so in the next few slides, what I want to do is kind of outline in just general terms, you know, what exactly is going on now as I see it. Uh, so big picture, privacy is not new. It's a hot topic nowadays, and there are lots more persons getting into the space. There's a lot more buzz around it. Every now and again, you might, you know, open up your news websites and you might see some references, something about GDPR, this and that, and shrimps and this kind of a thing. But privacy is not, it's not new, because even before there was any statutory protection in any of the jurisdictions that you might be in, um, many of you had, depending on your jurisdiction, common law type protections. And you also had some sort of protections in your constitutions. Now, as regards to common law, you know, there are a number of different sort of privacy related torts that have been discovered over the years, or well, decades and centuries really, for protecting what we now today consider, you know, your privacy rights. Now, obviously, the problem with the common law is it's by its nature a moving target almost, and so it's inherently imprecise in how it sets out the boundaries of your rights and the boundaries of obligations of persons as regards personal information, that kind of a thing. And then there's a dead obvious part, which is it's sort of pretty expensive and perhaps almost improbable proposition as regards enforcing those rights, because you're now talking court proceedings, you're talking lawyers, talking years and years of this and that just to essentially vindicate perhaps what maybe it might have been a one-off right. A limited right in a limited situation with limited damages, that kind of a thing. Now, as regards the Constitution, we sort of have the same kind of problem, where depending on the jurisdiction you're in, you may have a certain level of protection in your Constitution for the right to privacy. It may be broad, it may not be specific to include things that relate to informational privacy. Your Constitution may not mention it at all. And so there's a lot of variance in the Caribbean as regards the constitutional protection. But there have been some developments recently in the past 2 or 3 years that I think have kind of forced us to sort of rethink just how potent our constitutions are as a sort of source of privacy law and information privacy law. So, for example, there was the well-heralded decision of Robinson and the Attorney General out of Jamaica, which I think would have made the news in multiple jurisdictions. It certainly made the news here in Barbados, where I'm based now. Where essentially the Constitutional Court pretty much struck down a particular law in Jamaica. It's called NIDS. But the larger point for our purposes is that on their way to doing that, one of the things that the court did was to essentially affirm that in constitutions that we have in most of the countries, especially in the Commonwealth Caribbean countries, even in the absence of express written language, the three sort of root privacy rights that you could think of. And if you think back to Amalia's presentation just now, she listed a bunch of very nuanced and specific privacy related rights. All of those rights have their roots in one of three foundational privacy type rights. And that's informational privacy, privacy of your choices, and obviously, you know, privacy of your physical person, you know, your agency. And so they found in that case that essentially those rights are so fundamental to existing in a rights-respecting society that you have to imply it into constitutions like the ones we tend to have throughout the Caribbean. And so that was fairly significant. But the year before that, there was a case out of Barbados at the CCJ, which equally was significant for the implications of it. Now, this was a criminal law decision where the CCJ held that essentially, even if rights are only mentioned in the preamble to a constitution, and the preamble is basically, you could think of it as the introduction to your Bill of Rights in your constitution. And so the CCJ said that even though it's a preamble and it's on its face not enforceable, it actually is enforceable. And so what that means in practical terms is if you're in a jurisdiction where things like the right to privacy is only mentioned in the preamble to your constitution, it's not actually listed as an enforceable right, well, according to that decision, in theory at least, it opens up the possibility that you may still seek to enforce it constitutionally. But again, what do we know about enforcing constitutional rights? Extremely expensive proposition. And then also there are other practical implications as well, because depending on your jurisdiction, your constitution may only be enforceable vertically, i.e. against state actors, and for example, not horizontally against private actors. And so there are all these challenges that are bound up there. Enter privacy laws, specific laws that cover informational privacy. And in the Caribbean context, we've been having something of a slow march over the last, I would say, 2 decades in getting these kinds of laws passed. We typically refer to them as data protection laws. Now, as you can see in the small little mini table I have there on the slide on the screen now, as it stands right now, if you define Caribbean in the broadest sense of what Caribbean means, i.e. a state that is literally within the physical bounds of the Caribbean Sea, or a state that touches and abounds the Caribbean Sea, but because of cultural, historical, economic reasons, we consider it part and parcel of the Caribbean, i.e. Guyana, Suriname, Belize, etc. If you define Caribbean in that way, then of the 32 countries here, 18 have privacy laws now, and 14 still don't have full privacy laws on the books. This is actually something of an improvement over the last time I think we had this conversation, since I think the numbers have shifted into the column where countries have privacy laws. It's gone up by 2. That would be Jamaica and Barbados, who now have privacy laws on the books. Now, obviously, I think one of the challenges and what I want to explore in the next slide is that even in passing privacy laws, essentially, you don't essentially go all the way to potentially protecting persons' privacy-related rights as well as you possibly could. Now, what this table is meant to do is to drive home a larger point, really. And essentially, if you look at it, you'll realize, and I just literally just picked randomly different sort of principles and concepts related to data privacy or informational privacy. And we looked at the laws in these different jurisdictions. And we looked at the degree to which, well, they exist in those laws or they're not present in those laws. And as you can see, there is complete variance throughout the Caribbean and the select states that I pulled up. This isn't every single jurisdiction. I just pulled up a few because it helps to make the point. And so, for example, you look at Barbados and Jamaica, who are last out of the gate, and all the principles that I've called here are present in those acts. You know, the requirement to register with the regulator, whether or not you might need to have a data protection officer, you know, limitations on sending data outside of the borders of the country, breach notification in the event that there has been some kind of a breach in your systems. Now, all of those are present in those laws, but by contrast, if you're to look at, for example, St. Vincent, none of those features are present there in the act that they have. And so in and of itself, the larger point, I think, is demonstrated that there is significant inconsistency in how we've gone about passing these laws. And in some ways, I think this has to do with sort of the reasons behind many of the countries in the Caribbean passing these laws in the first place. So just a bit brief, a bit of brief history for those of you who perhaps aren't aware of the background. So back in about 2008, all the CARICOM countries and the Dominican Republic joined together in what we call CARIFORUM for the purposes of entering into an agreement with the European Union countries. And that agreement was called the EPA. And one of the requirements of the EPA was that you pass privacy laws. And that requirement was time bound. It gave them each country a certain amount of years to ensure that you had privacy laws on the books and that kind of a thing. Following that, most Caribbean countries, through something called HIPCAR, a HIPCAR project, essentially set about drafting laws, essentially model laws, that would be used as the basis for different jurisdictions passing their own privacy laws. And so what would have happened is that different countries would have interpreted how the model laws should be applied. Different principles were taken and implemented, others weren't. Some countries haven't even passed anything as yet. And so there is a significant variance because we sort of went the route of using model type laws as the basis for passing our laws. Now, I think the question that then comes up is, well, what's on the horizon for us in the Caribbean? And I've put up there essentially 4 large bullets to more or less, I think, focus my own thinking on what we can expect in the Caribbean in terms of data privacy in the next, few months and years. So I think consistent with the trend so far, we can obviously expect more general data privacy related laws to be passed. And I say that with reference to, for example, Jamaica and Barbados that I just mentioned that just passed laws. I say that also with reference to the fact that draft laws have been published in Suriname and the BVI. So they're looking to sort of, join the ranks of those with laws on the books. We also know that, for instance, Guyana recently advertised for someone to draft their data protection law. And so we know, and we can say with some confidence that the general trend, we expect it to continue into the next few years, where more and more Caribbean jurisdictions are passing laws. In the case of, for example, Belize, their recently published cybersecurity strategy for the next 3 years, it references throughout the data privacy laws, which they need. And so we know that this will happen. The other thing we expect to see happening, and I think this is consistent with the fact that many countries have in fact passed laws for quite a few years at this point. We expect to see more countries looking to amend their existing legislative frameworks. I could think of a quick example of Trinidad, for example. They recently put out an expression of interest for someone to come out to take on the task of coming up with a significantly amended law that will quite likely possibly, replace in total or significantly amend the existing privacy law they have on the books there. I expect to also see sector-specific laws because I've already seen indications of preliminary drafts in some jurisdictions of laws, which essentially are specific to a particular sector or subject matter. But in essence, bound up in those frameworks are essentially rules on handling personal information, and they're sector specific in that way. So I could think of, for example, of Barbados. There's a preliminary draft of a credit rating related law, which has significant language in there that deals with private information and the handling of private information. And so I expect to see that happening a lot. And importantly also, I think we can expect to see more enforcement action. And I say more because since the last time we had a conversation about the Caribbean landscape and what's been going on in the Cayman Islands, which is one of the more recent countries to have passed privacy laws, their regulator took enforcement action. And in essence, that I think is a positive signal, which says that if all the fundamentals are in place, then i.e. the a law is passed, appropriate regulations are in place, a regulator is appointed, and the regulator is resourced, then you can expect to see action. And so we've already seen that in the case of Cayman Islands. And I think that perhaps holds some kind of larger lessons for the rest of us in the region about what we need to do to ensure that we're at a point where the laws are actually enforced and there is a general sense that there's a need to comply with them because the regulator will enforce. Now, thanks to Coffee, we have the question of the day. Where will we go? Where will we go from here, ideally? And I think this is where I really want to focus the last, I think, 10 minutes or so of this presentation. Where do we go from here in the Caribbean? Because all of what I've done so far is to set up the landscape and to speak to the reality and perhaps some of the challenges that we face. Enforcement among them, lack of consistency, you name it, different principles. And so where do we go? And I think the first thing we need to do in answering this question is asking, well, what would we like to see when we get to wherever it is we go? And so what you're seeing on your screen now is essentially a list of features. And I'll tell you how I came up with this list. It's not necessarily just sort of my own opinion, but as I would have referenced earlier, this conversation we're having today is part of a larger conversation that's been going on for some years now. And in those back and forths, you know, different things that have been offered, questions, comments about what people I think would like to see and that kind of a thing. And so, you know, looking back at my notes and so on and my different conversations around those, I sort of put together this list of 9 features that, to my mind, and this is obviously subjective, and I'm hoping that this forms a jump off point for any conversation we may look to have after each of the presenters have presented. These are, to my mind, some of the features I think we'd like to see in the context of a putative CDPR, as we call it, the Caribbean Data Protection Regulation, if there was such a thing. I think certainly the free flow of data within Caribbean states is critical. It's critical to business. It's critical to creating efficiencies when data can flow freely within the region, within countries that are within whatever regulatory framework we may decide to come up with. I think one of the other features we'd like to see is that at a bare minimum, all the countries who are party to this CDPR will have essentially more or less uniform data privacy principles that sort of serve as the bedrock for the legislative framework and the total compliance framework at play in the different jurisdictions in the Caribbean. And so, for instance, if you were to look at, for example, look at all the laws in the Caribbean on data privacy that have been passed to date, or even the drafts as well, you'll realize that very often, even though the principles, the underlying principles, things like data minimization and that kind of a thing, those principles, they tend to be similar for the most part, but if you look closely, you tend to see, in some cases, fairly significant variances. You'll see where some countries have maybe 4 or 5 principles, others have up to 7 or 8 so-called core principles. So there are all these variances that I think need to be accounted for. I think we need to account for perhaps or think about the possibility of a unified enforcement mechanism in place. And this is, I think, just at the level of ideating, but I could imagine, for example, in the context of the Caribbean, where it would not be impossible, based on the framework that we put in place, for, let's say, a party in Trinidad and Tobago to, let's say, a private person in Trinidad who believes that some privacy-related right of theirs has been breached, to bring proceedings directly based on this regulatory framework against an entity that's based in Jamaica, for instance. The other point which is raised here, which I think is really significant for our purposes, is an idea of a singular enforcement authority that straddles multiple jurisdictions. Now, I say that because if you tend to lift up the hood, so to speak, of data privacy in the Caribbean, even though on the face of it, you go, wow, there more than half of the countries have passed data privacy laws already, and they're on the books or what have you. Others are looking to pass them. You go, wow, that seems fairly positive. It seems to be going in a positive direction or trending in a positive direction. But then you look a little further and you realize that quite a few of the countries that have passed laws have not actually put them into force as yet. And very often you'll go, well, that's disappointing. Why is that the case? And 8 times out of 10, when you ask questions, what you'll hear from persons on the ground is, well, it's a resource issue. The government simply doesn't have the money to fund a regulator, to fully set up a regulator right now. So they put a pause on this until funding can be secured. And so if you don't have a regulator, essentially what you don't have is someone with the primary purpose of enforcing the legislation. And so essentially what you have is essentially a law that is on paper, but it is not, it has no teeth. You know, it exists on paper, but there's no means of actually enforcing it in a real sense. And so to my mind, given the resource challenges that different governments are facing throughout the Caribbean, perhaps one of the things that could assist is having a singular regulatory body that essentially has scope and authority to enforce in multiple jurisdictions. The I think obviously it would be important to have more or less fairly modern data privacy features. You know, the stuff we've been seeing where based on experience, different jurisdictions in the world have realized that these things are important to actually having a fulsome and meaningful data privacy framework. You know, the breach notification, fines that scale depending on the circumstances and what have you. Those kinds of those kinds of things. Now, the I realize that time is against me, so I want to push through and deal with all of these points quickly. Now, one of the things that I think that would be, I think, really important is essentially one-stop certification for both, you know, persons within the CDPR sort of framework as well as persons outside of it. And so, if it is, for instance, sorry, I just got ahead of myself there. Let's go back really quickly. So let's say you are a controller or processor of personal information and this is personal information of persons within the Caribbean. In order for you to lawfully do so, because now you're talking about data basically leaving the Caribbean potentially, in order for it to lawfully leave the Caribbean, essentially what you could do is certify underneath the CDPR, or with, you know, perhaps with any other countries within the CDPR, and that certification would be good for all data that you process from within the Caribbean and within all the countries within the so-called CDPR. I think obviously this would bring immense benefits, again, for efficiencies, cost of doing business, predictability. All of these things I think would come into play fairly readily if you had a kind of one-stop certification mechanism for persons looking to process data of persons within the Caribbean. And I think the same thing goes for the certification or of safeguard mechanism for internal actors. So let's say you're a company within the Caribbean region and you're bound by the so-called CDPR. Again, regards to the country you're in, if you could go to the singular, let's say the singular regulator, for example, and have them certify your different mechanisms that you are putting in place to ensure that when you transfer data outside of the Caribbean, it's transferred in a manner that's safe and where there are sufficient safeguards in the destination. If you had a singular regulator to do that, it would make your work easier operating within the Caribbean, especially when you operate in multiple jurisdictions, you process the data of multiple persons in the Caribbean, you're looking to send it outside of the Caribbean for processing. Now, I think the whole question of country level flexibility, I think is an issue that I think would need to be addressed as well, because I think one of the challenges with these sort of supranational type legislative efforts or arrangements is that very often countries will still need some flexibility on certain particular on certain issues that they may need to address based on the specific circumstances or nuances of the local environment. You could think of an easy example, for example, the age at which someone can consent. Um, Depending on the norms in your country, you know, that may be as low as 16, it may be as high as 21. And so it should be up to countries to sort of still have the ability within this kind of regional framework to sort of set those things for themselves. And then finally, which I think is potentially a significant one as well, is the idea of extending the notion of data sovereignty. Now, if you've been following these conversations for a while, you will be aware that one of the biggest things people have been talking about is this idea of data sovereignty recently. In the past 2 years, it's become a significant talking point for countries. I mean, obviously, with everything that happened with Snowden and so on, you know, countries have realized that it's important for certain critical classes of data to be safeguarded. And in their minds, the best way to safeguard it is to ensure that the data never leaves these physical limits of the country. A popular example of that is Russia, for instance. Where certain, for example, social media companies are required to store certain classes of data that has to do with like Russian citizens on servers within Russia. Um, I would suggest that given the significant level of trust that is at play with most Caribbean countries, given our history, level of high level collegiality and so on, and the fact that we simply just get along in the larger scheme of things, never mind the different, incidents of insularity and what have you, we could possibly consider extending the concept of data sovereignty so that even if data is stored perhaps more cost efficiently on servers in, let's say, Trinidad, for example, even though the government that the data relates to, let's say, is in Antigua, because it's still within the bounds of a CDPR jurisdiction, it is considered to be still sovereign data in that sense. So it would be almost data sovereignty in extending itself to a kind of regional sort of concept, which is fairly novel. But again, we are a unique region with unique needs and unique perhaps opportunities as well. Now, the question now comes to, well, let's get down to brass tacks, so to speak. How could we possibly actually bring something like a CDPR into being? I think naturally our instinctive first response is, well, there's a GDPR, let's just do the CDPR the same way. The problem with that is the political framework at play in the European Union that allows a law like the GDPR to come into effect is not exactly in play in the Caribbean. So because of the level of political union that you have in the European Union, it allows them to pass a regulation like the GDPR, which has effect in all of the member countries upon being passed. We don't have a similar mechanism at play in the Caribbean right now. And so it raises the question that, well, if we are to do that, then we need to put those mechanisms in place. Now, I think given some of the challenges we've had in sort of, doing certain smaller tasks together and agreeing on those smaller tasks, that might be a big ask right now, especially given the current political climate. The other question is, well, can we go the route of model laws? And yes, we can. It's certainly the easiest way to achieve this thing, which is simply come up with revised model laws that speak to all the fundamental things that we'd like to see and leave it up to each country to essentially assimilate or localize those laws and pass them locally in their different jurisdictions. Of course, I think a critic might say, well, strictly speaking, we tried that already, and you see the mixed results that we got. And so perhaps it may not commend itself for what it is we're looking to do. Certainly from the level of accountability and that kind of a thing, and holding different governments to account to say, well, you said you're going to pass this law, you haven't done it yet, that kind of a thing. And so it brings us to the third option, which is the possibility of a treaty or international type, agreement or structure that would allow for this. To my mind, I think this approach may commend itself perhaps more than the other two, for no other reason than we already have live examples in the Caribbean of these kinds of structures playing out. Lots of examples. A good one right now off the top of my head is the CCJ, the Caribbean Court of Justice. If you think about it, technically speaking, there is this supranational court, and even forgetting the original jurisdiction. Think about it, the court, it has an appellate jurisdiction as well, and essentially each country that signs on to the CCJ, you essentially would have been party to a treaty. That treaty would have included a schedule with essentially what amounts to a model law, but obviously the requirement being that you essentially pass the model law more or less as is with minimal modifications that are necessary for localizing it. And essentially you have a structure that allows one single court to have effect and authority in multiple jurisdictions throughout the Caribbean. And I'm saying that in of itself, in a broad way, in a very broad way, commends itself as a live example right here in the region of how using a treaty or international type agreement as a basis could be a good jump off point for realizing this putative, this idea of a CDPR. Now, just going over my time a little bit, but I just want to close off quickly by saying, well, there are two ways to go about doing this, regardless of what we do. I suspect the treaty option might be the best. And that's my opinion of it. I'd love to hear your own views on what you think and why. But we have two options. We can build or we can buy. And when I say build, I mean, obviously to generate our own unique solution from scratch, perhaps come up with our own treaty framework that speaks to all the things and the different ideals that I would have mentioned on previous slides, or buy it. And by that, I mean, scrap a CDPR per se and simply sign on to an existing framework. Now, I say this because there are in fact existing frameworks like the Council of Europe's Convention 108, and I guess nowadays you call it 108 plus, as well as the APEC cross-border privacy rules system, which is what you call the CBPR. Now, I say that because both of those allow for different parties to essentially sign on to those treaties and essentially take on the different obligations that already exist in those treaties. Now, for instance, if we were to go the route of, in the Caribbean, of collectively going and signing on to, for example, Convention 108 plus, it means then that the laws that we would be required to pass are laws which would be almost by definition on par with the leading edge laws on data privacy now that provide the most comfort and protection to end users in terms of their privacy rights, things like the GDPR and so on. It would sort of force us to fast track ourselves towards passing those laws. Convention 108 plus also has certain benefits that are tied up in the treaty in terms of like support for persons who are looking to bring their systems up to scratch and so on. Similar, the CBPR. I mean, you might say, well, this is out of Asia, that has nothing to do with us, but the actual principles underneath it, the CBPR part, you'll be pleased to know that lots of countries have actually signed on to the CDPR that are outside of Asia, including the United States, Canada, Mexico. Now, I'm only saying all of this to make a bigger point that we need to think meaningfully and in practical terms about the best approach for us in the region, whether we build or buy. Now, on that note, I think I would like to close there and hand back over to the moderator. Thank you very much for your time.
Thank you very much, Bartlett. As usual, great presentation, and your collection of statistics and facts is always interesting to look at. So thank you so much. And there are a number of questions that have come in, and we will take care of them in the other section. I want to go quickly on to our next presenter, which is Vashti Maraj. And do some justice to her bio. Ms. Vashti Maraj has been a Director of Legal Services at the Ministry of the Attorney General and Legal Affairs of the Government of the Republic of Trinidad and Tobago, where she worked on ICT, telecommunications, cybersecurity, and intellectual property legislative agenda. For the past decade, She has worked extensively on national and regional projects in the primary areas of e-governance, electronic commerce, telecommunications, data protection, and cybersecurity from a policy and regulatory perspective. She has been involved in projects led by the ITU, the CTU, and the Commonwealth Connects, and is also a member of the University of Oxford Cybersecurity Capacity Building Centers Working Group and Cybersecurity Policy, Legal, and Regulatory Environment, the National Payment System Council of the Central Bank of Trinidad and Tobago, as well as the Board of Directors of the National Information Communications Technology Company Limited. Mrs. Maraj assumes duties on November 23rd, actually a couple of days ago, which was after I had asked her to do this session for us. So she was working at the ministry once she accepted, but as of November 23rd, she is now an advisor to the Digital Trade Policy in the Commonwealth Secretariat, where she will primarily focus on advancing the Commonwealth's work on digital trade, and will be working as part of a multidisciplinary team to deliver the goals of the Commonwealth Connectivity Agenda for Trade and Investment. Please join me in welcoming Vashti to this event. Vashti continues to be an avid supporter of the TT-MAG and is always willing to participate and share her knowledge and experience at these TT-MAG events. We sincerely hope that that won't change when she gets over to the UK. Good morning and welcome, Vashti.
Hi, good morning, everyone. Can you hear me?
Yes, we can hear you, Vashti.
Okay, thank you so much, George, for the introduction. And I must say that we've had excellent presentations by both the opening chair as well as the two prior presenters this morning, who have really laid an excellent palette in terms of the Canadian and international perspective on data protection, as well as the Caribbean perspective. I am actually here not to repeat anything that was said, but actually to add some perspectives from Trinidad and Tobago, as well as practicable solutions that we can employ moving ahead. So moving on. When I sat down and I had a team meeting with our fellow panelists, the one comment that I had to make was that I somehow feel that I've been here in this room before. I know that last year in 2019, we did discuss at the Internet Governance Forum, what is the scene within the Caribbean in terms of data protection, best practices, and where we can look to going in the future. But since 2019 to 2020, there have been several developments. I know many of us would like to forget 2020 and cross it off on our calendars entirely, but there have been certain things that has really changed the context in terms of how we do business. But more importantly, it has changed our survival within the data protection world. We've had novel coronavirus, and most of us have spent ridiculous amounts of times inside, online, and we have had to access work and also educational services, as well as do most of our purchasing online. That means that our online presence has just about quadrupled, if not multiplied over 100% from what it was before. And as a result of which, this has had certain repercussions for us as a Caribbean region. There have been increased cybersecurity threats. In fact, just recently, we've had the case, which many of us are aware of, within the Caribbean and Trinidad, of the recent ransomware attack involving Answer McCall, in which data involving numerous financial documentation, agreements, and personal identifiable information was harvested by a rebel and held to ransom, some of which was paid. And of course, there was the involvement of an international group to come in and assist with putting in the necessary technical fixes. That has not been singular. Even years before that, we've had the international controversial case of Cambridge Analytica and data mining and election interference. There's been a lack of proper operational business protocols and policies. Many businesses and even government services have been forced to go online in order to thrive and survive. But you know, it was almost like a sudden explosion where you had no choice but to move things from a manual-based environment to a completely electronic-based environment. But as a result of which, there would not have been that proper foundation of business protocols and policies that would have underscored the reprocess engineering of how you go about doing business. We do have data governance issues that have been in the field and we're aware of, but they're put more squarely into context. Because when you go online, and most governments, inclusive of the Republic of Trinidad and Tobago, we have adopted our cloud policy. There's also the issue of data sovereignty and data localization, which I know that both of my prior speakers would have touched on. When we decide to do business online, for instance, or even use government services online, do we really understand very clearly where our data is going? Where is it housed? Who has accessed it under surveillance purposes or otherwise? These are real issues, and there have been a lot of discussions in the last decade about the concept of a national government cloud or even a regional cloud for the hosting of data. There's also the issue where, and most business companies as well as governments, we have to create a business continuity plan in which there's redundancy or failover in the event that our services go down. Because a lot of governments and companies use portal services. In many instances, our backup is not located locally. And in other jurisdictions, you will find that that is the same. But the question that is to be raised is, who can we really trust? And where can we really trust to house our data? Is it in Canada, because they have an extensive regime? Is it in the US, because they have the technology and the support for it? Is it going to be in Latin America or Argentina? So there have been disparate levels of data protection, laws, and regulations within the Caribbean based on the analysis table that we would have had seen presented by Bartlett. And even not just in Trinidad, even in Canada, where you have one PIPEDA, but different provinces have their own nuances. And I will come and touch on that when it is that we look at regional solutions involving how we can have a common singular approach to data protection. There's also a lack of regional integration and coordination. And I will say this, every country, as part of its right to sovereignty, has the ability to make laws, regulations based on its own particularities. There may be international models, there may be international treaties and conventions, but we need to ensure that every country prepares the laws and regulations that are most suited to its circumstances. And we all have different circumstances. So where does that put us? I'm sure that we will be aware. We all have national ICT plans and strategies, of which data protection forms a part of. In fact, I'd go so far to say that data protection forms part of the essential omnibus framework that most countries within the Caribbean have enacted or in the process of enacting, involving electronic transactions legislation, data protection legislation, cybersecurity legislation, and anti-competition legislation. They all are interconnected and interdependent. Coming out of that, you've seen incrementally in the last, because I remember even updating this table recently because we've seen Jamaica recently enact legislation, as well as Barbados. And Guyana has introduced a bill. But even though we have legislation on the books and governments understand that it is a priority, there has been a critical failure to establish a national independent regulatory body. And when one has to contemplate regional collaboration, just like we would think about collaboration in terms of competition or telecommunications, the lead on collaboration generally tends to be a regulatory body, because they would be the one who would also champion enforcement as well as policy and strategy making. So what about the Republic of Trinidad and Tobago? We do have a Data Protection Act that has been in existence since 2011 that has been partially proclaimed. And in 2020, even if we were to proceed with full enactment of the legislation, it is at present in need of dire updating. Because within the last 10 years, we've seen a lot of developments in the international field, not just with GDPR, but developments with regard to cross-border data flows and the integrity of information. We do have the National ICT Plan, in which data protection is a part of the strategic trust number 3. But where we're at is that we as a country, and as many other in the region and internationally, are moving more towards a digitalized world and a digitalized presence with regard to both private and public sector. We have TT BizLink, or single economic window, in which we have our commercial interactions and we do interface with international companies. So in order to promote the ease of doing business and even foreign direct investments, companies internationally must be ensured and reassured that their information that they share in order to undertake business can be trusted and they can have confidence in our system. We do have e-tax online, and even citizens, when they submit all their personal information and all their tax data, need to be assured that the systems that they send this to, they can trust and there will be no data leaks. We recently at the Ministry of the Attorney General have piloted online filing and end-to-end online payments with delivery straight to your door for all services under the Registrar General's Department, as well as the Intellectual Property Office of Trinidad and Tobago. And, you know, even within the legislative or judicial fields, to be exact, because of COVID, the court system has had to now facilitate virtual hearings and e-filing through the judiciary. This is now tantamount to the government and agencies being the largest custodian of information and personal identifiable information. So what necessarily needs to be put into place to ensure that people can have trust and confidence in what we are doing? Well, it is clear, abundantly clear, that we really do need to establish the Office of the Information Commissioner. But in addition to that, there's a clear need for data classification standards, regulations for data retention, sharing, and disposal, open data policy and guidelines, as well as the revision of the legislation. So one of the things that Amalia referred to, and I entirely agree, is please don't wait on your regulations to put things in place. So what if our government now takes 20 years to fully proclaim data protection legislation? What does that mean for private sector companies, banks, even the governmental agencies that are now going online? There are standards that can be applied. For example, the ISO ICC 27701, which relates directly to information security management, as well as GDPR. Bartlett would have also alluded to the fact that the Council of Europe has 108+, which many countries, even if they're not signatories to, do look at for precedential value, as well as the APEC CDPR model. I'm also pleased to advise that the Commonwealth Secretariat has, in this year, 2020, finalized the formal Commonwealth model on data protection, for which many countries in the Caribbean has had input, which seeks to incorporate and assimilate the GDPR, APEC, ASEAN, as well as 108+ model. Yes, I'm putting in a plug for my new organization. Take a look at it. It's actually quite comprehensive. But practically, what can we do as a country and even as a region? Data protection through design and defaults And that is something that we should apply as a basic standard. When there's something that we look at, when you're going to consider building a system in order to address a problem, build it to last. Don't build it to be proactive, but build it so that by default, it will be able to not only withstand and treat with your current situation, but can evolve to treat with new and emerging situations. Minimize organizational risks through effective business data management. And I would say this particularly in the Caribbean context, because we have many multinational agencies and companies that operate within the entire Caribbean, from telecommunications companies to banks, to everybody has a massy bag, to the fact that even our insurance companies are regional in nature. And you will find, based on the anti-McCall attack, which is a recent example, that once there's a weakness on one level with one branch, you stand to be able to access the data and information throughout the entire organization within the various jurisdictions. Part and parcel of that is ensuring that we institute and comply with data security standards as a matter of course in our daily operation. And, even though, and I'm alluding to don't wait on regulations, and it seems very interesting coming from a lawyer, and more so a lawyer that previously worked in the government for the last 15 years. But we can take a look at what maintains even in other similar industries or sectors where there are voluntary and mandatory codes. And you find that voluntary codes, for example, the banking and insurance sectors that are developed actually work among their associations, and they are often frequently updated. And it is something that we can consider looking at, not just within our own jurisdiction, but on a regional level. And increase public sensitization and awareness. I cannot say this enough because, even listening to our conversations, it is often esoteric. When it comes to data protection, we talk about different acts, we talk about different models, but when you think about practical application of data protection, you have to think about every single person within the Caribbean understanding the fundamentals of what are your personal rights when it comes to the protection of personally identifiable information. I know that my colleagues would have touched on different things that could be done in terms of looking at a Caribbean data protection model. But there are just some things that I'd like to put forward based on my observations, but also my experience in working in this field. Even though we can look at having a common body, like the CCJ, for instance, and I know the CCJ has had decisions and judgments that were made that touch and concern the constitutional right to privacy. The fact of the matter is that it can be addressed on a regional level because we do have CARICOM. And there are systems that we have seen work. A good example would be when it comes to our regional security center and advanced passenger details and screening for the entire region. Whether we like it or not, there are certain things we all need to collaborate on, but it requires political will and prioritization that for the entire region, this is our priority. This is what we're going to collaborate on, and it can be done. I admire very, very much the OECS. They have a common currency. When you think of a comparable body or group within the Caribbean that is like the EU, it is the OECS. And even though I'm not a member of the OECS, I really do admire their integration to have a common currency, common bank, common telecommunications operator, common policies that are applied across the board through common agreements between their governments. And that is because the OECS understands quite clearly that they are a small group and a small fish within a big pool. And the only way in which they would be able to actually get strength in their negotiating power, but also strengthen their actions, is by coming together. And perhaps we can look at taking a page out of that book and look at the OECS model. I think it is very possible for us. I've mentioned the prioritization of harmonization of domestic legislation with foreign standards. But I want to actually indicate that one of the things we need to look at is the integration of work taken by various regional and international organizations, all in the area of data protection. I would give you good examples. We've had the ITU come in and do work in and around 2009 to 2010 in relation to common models on data protection, and they have developed model legislation. Then we have the CTU develop a model for 21st century government in which you have harmonization of standards. You also have ECLAC recently conclude a study with several Caribbean countries on data protection, compliance with GDPR, and ways in which to close the gap. And we also have CARICOM looking at common ways in which we can deal with the cybersecurity action plan. You have so many organizations working on so many similar things that it is worth our while to consider the integration of these efforts in order to look at developing a model or guide that will guide Caribbean members. And I would stress and underscore that there needs to be continuous evolution of processes on a private and public sector level to deal with our ever-changing data universe. So without more, I will turn it back over to you, George.
Thank you very much, Vashti. Good. So at this point in time, we will switch over to a question and answer period. So a little bit of wrap up and next steps. So I'd like to have our three presenters back on spotlight, and along with Danny Jagannathan, who is going to assist us with the questions that have arisen in the chat. And I do want to remind our viewers or attendees that if you missed any portions of the presentation, it will be up on our website sometime after the event, and you will get an email to do so. So can we have is Danny Jagannathan on? Sanjay, as if Danny's not on, can you take the chat questions?
I'm on.
Okay. Thanks, Danny. Okay, so Danny, you want to lead us through the first questions? We asked that questions be directed at the presenter who is on the panel, so you can call the presenter's name who the question is directed to.
Right. There were probably more comments than questions. So we're still fielding questions. So people feel free to use the chat to ask any of your questions. And in terms of a number of comments, well, a lot of the comments were addressed in the discussions. But there was a comment raised by Amalia. So I'm going to start with that one. When we were talking about the various tools to actually really either have a data center or to actually establish a data protection law or data protection regulation law in the region. Amalia, you said that Canada has the technology tool, and you also commented that and better data protection than the US. Can you expand more on that?
Right. So just by way of introduction, so a lot of the big cloud providers, and particularly Microsoft, Google, they now have data centers in Canada, and that's been done on purpose. So my colleagues in the US, and I have to tell you, because I've been counting, they have over 300 laws of privacy in the US. So you're going to say, well, How can you claim that Canada has better data protection? Well, we're going through a transformation of the law, and one of the biggest issues that is happening in the US with the Schrems II judgment is the lack of redress, the fact that me as a citizen of any country, if my data is transferred into the US with top technology, I have certain laws that override the I guess the governance of that data in those organizations, and those laws are of national interest, and they can go and take the data and investigate it. So the organization can't do much. I mean, what they can do is they can place their data centers in another country, like they did with Ireland. As you know, that's been a famous case with Facebook, and it was Microsoft, and they had a data center in Ireland. So what I'm trying to say is that our legislation is now being updated, and there's going to be powers given to the regulator that we've never had before. And those powers are specifically targeted to address, it's a bit of play upon words, to address the redress. So to address the fact that the regulator needs to speak for the individuals whose data protection rights have not been observed. And that's what I meant with that comment. Plus, we have the technology.
Okay. Great. Well, let me start with some of the questions, and questions were flowing in from the beginning. One composite question: will a CDPR be possible without full recognition of the Caribbean Court of Justice? And a subsequent question from the same person: could this not also be a part of the CSME construct? I'll throw it out to Mota Bartlett. It wasn't directed to anybody in particular, but I suppose Bartlett and Vashti, you all can comment on that.
Sure, I'd be happy to. So the first one was whether or not a possible CDPR type arrangement would be possible without the CCJ. I think the answer is unfortunately a lawyer's answer, which is it depends. We're still very much at the stage of ideating, sharing ideas, bouncing ideas off of each other about what could be. And so we can't speak definitively about whether or not we would need them or would include the CCJ as part of, let's say, the enforcement mechanism or the adjudicative body to determine ultimately whether or not, rights have been infringed or not, because we're literally just at the preliminary stages of the discussion. So we can't actually answer yet because we're not at the stage yet to answer that meaningfully. Can I potentially see a role for the CCJ in some kind of a regional arrangement like this? Of course, absolutely. They have, I think, demonstrated repeatedly over the years their competence and ability to be objective in looking at matters and arriving at conclusions on them. And in that sense, I would have full faith in their ability to be part and parcel of some of the mechanism in some way, perhaps as the final appellate body from decisions made pursuant, to the CDPR. Perhaps let's say there's a regulator, or as I would like to see, a singular regulator, for the entire framework. And let's say the regulator makes a decision, perhaps that could be appealed somewhere, and ultimately the final say would be with the CCJ. That could work, for instance. I don't know if you want to go on to the next question, or if I should probably pass it back.
Well, I mean, with the CSME or
yes,
a next question? Well, go ahead with the CSME comment, yes.
Vashti, you want to jump in?
What happens is that, you see, the question about the CCJ is a very tricky one because we're not all parties to the CCJ. But Bartlett is correct in indicating that even if you have a joint CDPR regime, different jurisdictions can opt out of or opt into having the CCJ as their final appellate court based on their supreme law construct. So if, for instance, let's take Trinidad has as a court of appeal, and then its final appellate court is a Privy Council, you can have an appeal to a decision to your local court of appeal, and I suppose the same thing would apply for all other countries. You would have a court of appeal in terms of any challenging of a decision, but the decision as to what would be a final court of appeal would depend on the construct of your supreme laws. And that shouldn't be a challenge. The real issue is getting countries to agree on having a common construct in the first instance. I guess, Bartlett, you can address the CSME part of the question, because I also have an opinion on that.
Yeah, so again, I would kind of give the same default, sort of proviso, which is it depends. Essentially, as I understand the question as well, can we do this, can't we simply essentially use the CSME framework to do this? In a strict sense, absolutely. Absolutely. I could see a further revised, treaty of perhaps not Chaguaramas this time, but, Tuna Puna, I don't know. That sees to further revisions. And for example, one of the things I've always said about the CSME overall framework and the revised treaty was that it missed an opportunity to enshrine within the treaty that underpinning this desire for free trade and free movement and what have you was the importance of the right to privacy, to all of that. You'll remember earlier when I cited this decision out of Jamaica, Robinson, that's one of the things that I found really insignificant about the decision. They were saying that, look, in a rights respecting society, it is so important, privacy is so important that you can't essentially enjoy all of your other rights without having an implied right to privacy. And I think in a larger construct where you have multiple jurisdictions looking to sort of join together in a treaty framework on things as fundamental as free movement, free trade, I think you could also make the argument that it is impossible to truly do some of those things properly without a fundamental right to privacy being enshrined in that fundamental document. And so in theory, I could see a further revision that, because that takes that approach. And the reality is there's precedent for it. The TFEU, the Treaty on the Function of the European Union, if you read through it, you'll realize that they do have provisions that speak to the respect for the right to privacy. And the ultimate aim is, a bit more political, but largely the same, which is, allowing for a sort of single market type structure and a aligned inter-country connectedness. So yes, I think it could work, but that is not to say that a standalone framework couldn't be as effective, because you could argue that if all the minds are focused on the standalone arrangement, a standalone treaty agreement, then there wouldn't be the larger need to involve other actors and factors and ensuring that it aligns with other provisions that have to do with this, that, and the other. Arguably, you could argue that there's a benefit to doing a standalone sort of arrangement to enact this CDPR idea. But I certainly see value in using the CSME framework, the existing framework, as the basis, further revising it to sort of enshrine certain things.
Okay, Vashi, any other comment as well?
I tend to agree with Bartlett's points, and I would add something to it. You see, within the Caribbean, we all have constitutions which protects the right to privacy. And, Caribbean jurisdictions, they are brought together in CARICOM to pursue certain similar goals. And even in the preamble, one of them is to uphold our constitutional rights. And I think, yes, there are certain CARICOM bodies that have been set up, for example, Quoted for Trade, Competition Commission, because over the years and since its inception, CARICOM has understood and recognized that there are certain priorities that affect member states. And in terms of coming up with a CDPR, there needs to be a regional body. It is something that could be contemplated. It may involve an amendment to the current Treaty of Chaguaramas, but even now under current construct, I'm a pragmatist, and I believe that sometimes we spend a lot of time in trying to build up a new structure, and this is one of the reasons why many countries in the Caribbean have not set up their information commissioner or data commissioner, because of the cost and the time and all of the fundamental requirements in setting up new structures. But there's also the ability to start off or start in the right direction by using current structures. And that is why I would point to certain regional organizations that have that mandate. For example, CARICOM Impacts has the responsibility for cybercrime. But you find that CTU, even though it has the responsibility for telecommunications, also touches on concerns on a single ICT space with the harmonization of laws. We also have the ICT 4D Secretariat within CARICOM. In my humble perspective, once there's an identification of a priority, it is good to take a start by working on what we have. And once it is that you start seeing work being generated that augurs to the benefit of the CARICOM region as well, you will get traction in order to take that further. But that would be my take on it.
Okay, good. So it sounds like use what we have and actually enforce it or implement it or use the soft touch approach to get countries to actually abide by it. Let's switch a bit because one person was made this comment. I want to see specific exceptions to data privacy laws for sharing of data related to national security and law enforcement. For example, tracking sex offenders, murderers, etc. I want the panel to comment on this.
I can start if that's okay. Just to say that there's, as far as I know, and this is material that I share with my students at University of Toronto. There's been a lot of let's say frowned upon practices in the UK with police. As you know, City of London has a lot of cameras. There's a lot of surveillance. So I know I'm going a little bit away from the topic of criminals and the data being shared. Of course, police enforcement authorities have to share the data cross-nationally, across borders. But one of the things I wanted to mention is that the UK police, law enforcement authorities, they've actually created a code of conduct for the police, and they worked with the privacy commissioner at the UK to actually understand how the Data Protection Act of the UK will map onto the code of conduct for the police. So they now have privacy principles that match with their code, the code of conduct issues that they have, or the topics that they have, which is, I think, the right thing, the right approach, because it's absolutely critical that data is shared regarding criminals. I mean, that we don't want sex offenders, we don't want criminals, we want the police to do their work. But there's always a way to do it in a trustworthy way and in a good way.
Fantastic. Any of the other panelists? Okay, well, let's move on to another.
I think Vashti wanted to add something.
Okay.
Just very quickly, and I want to make it clear, even though we have a constitutional right to privacy, at the end of the day, your constitutional right to privacy stops when it begins to encroach on the rights of others. And it is with this proviso that you would find that many jurisdictions, for example, the United States, and we are actually looking at this in terms of establishing a sex offenders registry. It is because, and putting it online, it is because we understand the rights of a criminal and for what you've done. But we also understand that there's a countervailing and counterbalancing right to protect members of the society. And, you know, with this knowledge, or a lot of people don't know anything about someone when they meet them, even less so sex offenders who incorporate themselves into daily lives. And it is something that we need to take into consideration when it comes to that level of criminality and what we do to protect society. And it's one of the provisos that we apply.
Good. And somewhat related to this, current data protection regulations really hold government to the same level as private sector. Yet our education ministries have had to upload children's data to online classroom software. Private businesses are handling our health data for contact tracing. So the question is, how will that be managed or disposed of? And who is the responsible party, the business or government? Anybody willing to volunteer?
I can start, and then my colleagues can answer a little bit more on the Caribbean side. I just want to reassure you that we have the exact same challenges in Canada. And as I mentioned, and I know it's over an hour ago, I barely remember what I said, but I know that we have a very big problem with school boards, Ministry of Education, where they are not, there is no actual legislation that says at the national level that says the school boards, the way they have to protect, and yet these are our most vulnerable, our children. And also the way universities, they take on software without doing the proper due diligence. And I know Vashti mentioned privacy by design and default. That is very near and dear to us Canadians. It's been drummed into us by Anne Kavukian since forever. Yes, there are concerns about children's data online. There are no standards, and I want to say that in all the other ministries in Canada, there are very good policies. The level and the governments in Canada, they have pushed cybersecurity and privacy policies to a great extent, and they're very good. But with the ministries, with the education, for some reason, that sector fell into this void. So that is a concern for us too. There has to be, their policies have to be enacted in those ministries. There's no question, because that is the most sensitive data we have. It's our children. And as far as the pandemic, that is also something the Canadian government is looking into. There's no clear guidance yet, but we all privacy advocates and professionals are saying, okay, we get it. We have the contact tracing app. The Canadian app has been deemed as one of the least privacy invasive. In fact, it's really, if you have an Apple phone, it's nothing. You cannot be identified. However, we haven't told the doctors, the clinics, the nurses, how long can this data exist, right? So there's this push, from us, the advocates, say there has to be a limit of retention of this data, unless it's, of course, de-identified and used for research. And that's what I wanted to mention.
Okay, well, on to the next question. And from our chairman, Ajmal, any single country in the region is too small to be commercially viable for a true data cloud infrastructure. If we do this at a regional level, then there's no direct connectivity or regional IXP, for example, between the islands. Hence, the data will have to go to Miami. Is this being considered? How feasible is it to keep our data within our region? And should we accept our data will always be exposed to the US? Now, that's a big idea for our regional participants.
So here's the reality. There is a short answer to this question. Separating data and hiving it off and limiting what goes where is very much possible. And in fact, there's lots of precedent for it. In fact, a big part of the whole, for example, I think data sovereignty type conversations we tend to have, the center on that very idea that you could create a regulatory framework that prohibits certain classes of data from being transferred out of your country. You put the appropriate controls in place, and that prevents that. I think probably the question that we may want to ask though is whether or not this is ideal or desirable in particular circumstances, especially data for commercial purposes and what have you. On a more practical perspective, I mean, forget the law for a second. I think the more we do work with our IXPs, putting them in place, the more we can encourage the private sector actors in the telecos and so on to actually have backbones that connect the islands directly, instead of everything having to go through a terminal in Miami or alternatively down through South America and then back up or what have you. It then augurs well for limiting the degree to which even just general data in general will have to leave the region to move from, let's say, a data center in Trinidad to the person who's looking to process or use that information in Dominica. That's as far as I'd want to go at this point.
Yeah, and my comments were regarding the choice that you can make with cloud service providers, especially the big ones, to direct your data. So if your concern is the US, you can direct your data to other data centers. If your concern is about keeping the data on the islands, I don't know understand the Caribbean, to the level where I can speak articulately about it, but the power is in numbers. So if more of you, of more businesses are putting pressure on these cloud providers, they're actually going to do the right thing. So they may create data centers in the Caribbean. So the whole point is that the Schrems issue has basically thrown the power shrunk the imbalance of power between the little business owner and the big cloud providers. And as you know, the big cloud providers are now working on a European code of conduct because they're realizing they can't just impose the way they want to do business with these massive privacy violations onto Europe in particular. So they're now starting to, I guess, come to the negotiations table to say, okay, well, maybe what if we were to show you that we're following a code of conduct, and part of that will become the data sovereignty will be an issue. The other issue that was brought here is about data leaving the country and whatnot. Well, you have the ability to encrypt the data, so your data can leave the country and can come back, and nobody can put their hands on it.
Right.
Okay. One of the more general questions, do people generally understand the privacy risks of their personal data? And this is not just for the Caribbean region, but we have Caribbean representatives who can comment on this. But Amalia, you can actually comment on it from a Canadian perspective as well. Do people generally understand the privacy risks of their personal data?
Most people don't. People generally, you would find that, do you know most people when they're going to purchase something at a store and they fill out a form with their email address and their name and their number or what have you, and just give it to them so that they can put it in their database or what have you. They don't understand the implications of that. In fact, it's very dangerous now that we've moved education now online, and kids who may not have been exposed to internet-based teaching or online teaching and now having to do it all the time, and many times not under supervision. You find that that creates a host of challenges, but the way to deal with it, and I'd mentioned it in my presentation, is public sensitization and training. And that is not just to adults and businesses and to banks and to governments, but it must start even at the very basic level. Every child that I know, particularly the one who's running around like crazy in the background right now, is a digital native. And they are born knowing how to swipe. And as a result of which, they just go about things and they don't understand the risks that they expose themselves to, not just in terms of cybersecurity, but in terms of the information being harvested about their proclivities, their likes, dislikes, what they look at, that leads to data mining and profiling. So my honest response to that is that the majority of people are not aware, and they take risks that they're not even aware that they're taking.
Yeah, I tend to agree with you. And I would have said, if you asked me this a year ago, I would have said Canadians, there's been surveys sent by the Privacy Commissioner of Canada, and over 50% of Canadians are concerned about what's happening with their data. So they know something about how important their personal data is. But I wanted to give you the example of the pandemic right now, where we've been thrown into this online world, and there's unprecedented, cleverly worded phishing emails and all kinds of malware and all kinds of nefarious things happening behind the scenes. And a lot of employees that are working from home have never worked from home before. So they really don't understand that if they click on something because they have a notification from their Yahoo Mail, it's actually going to affect the network of that company. And one of the things that I've said, and I said it in my panel last week, is governments all over the world have not done a good job to actually educate on digital cyber safety during this period. It was all about the pandemic. It's all about the virus that's killing us. What about the cyber attacks that are killing us? What about ransomware? What about, so much hacking and cyber activity that is out there against us? And there hasn't been any education on that at all.
Yeah, I tend to agree with my co-panelists. I certainly don't believe that there is enough. I mean, I can't tell you that I've seen any data research, or certainly none specific to the Caribbean, on the level of knowledge or awareness of everyday people. But my own sense of it, just living and existing in the region, is that for the most part, there is a significant gap between where persons are and where I think we ideally would want to be in terms of our knowledge and awareness of our rights, of our individual privacy rights, and that kind of a thing. I do believe it's changing somewhat in a positive sense. I think more and more people are a little bit getting there. I mean, if but for things like watching all these movies, the social network and this and that, and seeing what companies like Facebook are doing, I'll never forget, when a couple of years ago, my then senior burst into my office and said, he watched that movie on Netflix, that one about, Facebook and what they do with the data. And he's like, no, I get it, Bart. No, I get it. So there is some amount of change, but at the same time, the environment is dynamic. And what I would say is that, I mean, the reality is, when you think about personal information being used, possibly misused, I mean, nowadays, a ready culprit is, social media platforms themselves. And what they do with your information and how they use it, against you, so to speak. They are becoming more sophisticated now, at figuring out ways to sort of induce you, or to compel you to want to click yes, I agree to you doing the same with my data, even though you haven't even read it, because you just want to get on back onto the social media platform and get a dopamine squirt. And so it's an evolving environment, and so we need to come up with, I think, new and creative ways to kind of keep the sensitization game going, so that people are aware of what happens every time you log on and you do stuff, you share information, as I say, from going to a store and giving them your information, your name, email address, to going to your doctors or to the, health clinic, logging on online to your online banking. There's lots of significant and personal information that's being passed and processed. And there are significant implications to that. So I think it's a continuous game of finding new ways of ensuring that the appropriate interventions are made to the right audiences at the right age levels. For example, to use the example of my co-presenter, her child is a digital native. He's born learning how to swipe. So we need interventions that are appropriate for him and people like her child, as well as for adults, and that kind of a thing.
Another comment I can add is, since there's a lot of consultation going on with regards to the current education system in Trinidad, perhaps there's some sense in including within our education curriculum sessions to sensitize the younger people while they're young and while they're actually playing openly within the cyberspace, to help sensitize them as to the privacy issues related to sharing their data online. It's just a thought.
Danny,
Now,
just as a time check, you have 3 more minutes left.
Okay, well, I think we've run to the end of the questions. A lot of the other chats, comments. In fact, one that is a thread that is coming through is relates to what you had mentioned, Bartlett, about HIPCA. HIPCA established model laws for CARICOM members to enact, including data protection laws. Now, your comment is that HIPCA is outdated because it was done several years ago. Some of the questions came up is, how can we then, how do we suggest that we treat with this legislation on a regional basis, further noting that these legislations require updating to treat with today's environment?
I think there are different ways to sort of tackle that. I mean, in a sense, this overall conversation we've been having today is literally targeted at that question. What is the appropriate next step given the reality we find ourselves in with, outdated legislation, outdated models, what have you? If it is that one is looking to go the route of, model laws, then strictly speaking, I mean, Vashti would have mentioned a number of options that I think are available now to look to for precedent purposes for what updated, modern, sophisticated data privacy type laws, model laws are, and what they could include and what we might wish to take from them for our purposes. So I think that's a part of it. I think. To the larger question, to my mind, though, I don't know if model laws are as effective as we'd like them to be, simply for all the reasons we've discussed already. You implement a model law, or rather, you publish a model law, but then some countries take 6 months to enact it into their local laws. Some take 6 years, and some never get there. And so the question then becomes, what is the overall context in which you're trying to get these model laws passed? Is there some kind of incentive mechanism in place? Is there some kind of a stick mechanism in place, that's associated with the model laws that will ensure that they actually are passed, or even when they are passed, that they're passed in a form that is substantially similar to the actual model law and what the model law was trying to achieve?
Good. I think, Danny, we'll call it quits there, and
So,
we'll ask. Thank you very much, Danny, for taking those questions. I'll ask the panel. You have 1 minute to make some closing comments before we go up into the next slide, which is just a wrap up. So let's start with Amalia. 1 minute to closing comments.
Great. Thank you. I was reading through the questions, and I'm just thrilled to see so many questions. There's a lot of questions about what can we do now? Do you have a framework? There are a lot of frameworks out there. COBIT, there's an ISACA framework, is a framework based on OECD. They've looked around the world, and it's got 14 principles, much like the Australian law, I think, has 13 or 14. You have a lot of frameworks out there. There's the ISO standards Vashti mentioned. There's the ISO 29100, which is the privacy framework, and there's the ISO 27701, which is more specific to the privacy program. So tons of stuff out there. I'm happy to, I think what we will share on our managed privacy. I don't want you to take this as email me, and I'm not selling anything. All I want to say is there are a lot of models out there. And if you remember my slides, don't wait, build your own model. You don't have to proclaim it in the industry in terms of, yes, you want people to adhere to it, but you don't have to wait and go through a lot of meetings. And once you adhere to it and another significant business partner adheres to it, you're going to all point to it. And when other partners come into your market space, you're going to say, but are you adhering to my code of conduct? Because I don't know if I can trust you. Although those would be my last comments.
Thank you so much, Amalia. Bartlett, 1 minute.
Well, I mean, thanks again for having me. I really enjoyed this conversation. Looking at the comments, I think where I would probably leave us is urging us to probably take on the hard task of figuring out what's next for us as a region, in this overall sort of, I guess you could say, mission or journey we're on towards having a more standardized playing field in the region as regards data privacy and possibly cybersecurity and so on. I think we need to think deeply about what the next practical steps are, and figure out how we can start taking those steps. We've mentioned different things variously. I've seen in the chat different options that have been put forward about who we should speak to, what we should do when we speak to them. But I think that's definitely going to be important. I mean, this is a region-wide problem, and so we probably need to target the relevant parties at the appropriate level to bring the conversation to them, and perhaps not just to say, well, this is what we want done. This is what is wrong, but here are possible solutions. I think we need to show up with those potential solutions, so that it makes it easier to sort of get to the next level of actually seeing some action happening. I think that's one of the problems we all face. I think Tracy identified it, Tracy Hackshaw in one of his comments that, people go, well, this is more talk, more talk. Well, to get from talk to action very often in these situations is to show up to the table with your solutions. And I would implore us to figure out how we can go about, fine tuning those potential solutions so we can go to that next step.
Good. Vashti?
would like to reiterate my thanks to TT Mag for inviting me and the co-panelists to participate in a very engaging conversation. There are a few takeaways that I'd like to add to this. Yes, there are many models out there, and there will be more models that we can look at. But from my experience in terms of preparing draft laws and taking it through the parliamentary process, each jurisdiction has its own particularities, and in looking at any model law, we must take it and apply it to our own circumstances, even making consequential amendments. But one of the things I've learned over the years that will assist each jurisdiction and the Caribbean greatly is that within your legislation, you insert a mandatory review clause within at least a 3 to 5 year period, so that you always ensure that when you put in the legislation, you can assess its efficacy, but you can also assess whether it needs to be updated based on developments in the sector. The second thing I would have to say, and I think we've all reiterated it, but I can say this from personal experience. If you do not have the political will at the very top of your hierarchy to push for the legislation nationally, but also on a regional basis to have consensus ad idem among regional leaders that this is an area of great priority, we can only sit here and talk about it in a very theoretical way. And I will say to you that, you know, they say that adversity is the mother of all creation or father. But with COVID, there have been many ups or downs, but one of the ups is that you have no choice now but to evolve to deal with your new environment. And part of digitization is ensuring the necessary protections. I would quote one of my favorite permanent secretaries in saying, Vashti, the way to solve this problem is tell them that it's Corona. It needs to happen now. So with that being said, I thank you again, and I'm sure that we will look at the questions and comments made with the chat in the chat and perhaps be able to assist further in providing answers.
Great, thank you, Vashti. So really, it leads us to the next session, which is really a quick wrap up. And I'd really like to thank our presenters who have been of great service and value to this conversation today. Your comments have been really, really appreciated. And from the questions that you've gotten, you'll have seen that there's a wide and varied spectrum of people who are involved and knowledgeable and who are looking for answers to the problems. So on behalf of the Trinidad and Tobago multi-stakeholders group, Vashti, Bartlett, and Amalia, thank you so much. I want to spend 1 minute and say some congratulations to Bartlett for finally making the move to set up his own practice, handling matters in Barbados and expanding into other Caribbean countries. I think Bartlett was formerly at Lex Caribbean, and he's now started his own organization called Chancery. Is it, Bartlett?
Well, I mean, hold on, am I on?
Yes.
Yes. So I am essentially on my own. I wouldn't say I've started my organization.
Okay. Okay, great. Congratulations on behalf of the TDMAG. We wish you the best of luck and great success in this new venture. Also, I want to say again, congratulations to Ms. Vashti Maraj, who assumed duties on November 23rd as the advisor in digital trade policy on the Commonwealth Secretariat. And so we'll be probably losing her to London-based as soon as this COVID thing gets over, where she'll primarily focus on advancing the Commonwealth's work on digital trade. So thank you so very much, Vashti. Congratulations on your new role.
George, I'll be focusing on the Caribbean as well very much.
Okay, great, great, great.
I won't be a stranger.
We will not allow you to be, Vashti. The other thing quickly is, Amalia, thank you so much. This is your first experience of doing stuff in the Caribbean, and you've been a great provided great assistance in the whole planning of this event and participating in all the pre-calls. To the attendees, Amalia has made available to us a document called Understanding GDPR, the role of standards in compliance. And Amalia has given us permission to share this document also, so it will be shortly up on the website for download as part of this presentation. Amalia, just confirming, I wouldn't be breaking any copyright laws by saying that.
No, this is officially available online from the Canadian Standards Council, and I love the fact that it's the Standards Council, so it's a very authoritative document that you can look at and start getting some ideas,
Great.
yeah, about standards and how important they are.
Great. So thank you all so very much. I want to particularly thank our attendees who have stuck with us for this morning's presentation. We had a couple of glitches in the early morning where a couple of people couldn't join, but it was solved later on in the morning. And the sessions will be available on www.mag.tt sometime later this week. I want to take the opportunity to invite you also to our next event, which will be happening on January 29th at 2021. And it's the Trinidad and Tobago IGF, Internet Governance Forum. And the topic will be digitalization, the new normal. So thank you all very much, and please enjoy the rest of the day and have a safe one. Thanks, everyone.